Hi everyone, welcome to our CMA classes. This is Soumya Santosh, a CMA finalist, and today I'm going to start another chapter of Corporate and Economic Law for CA final and CMA final students. And the chapter is going to be Prevention of Money Laundering Act. So let's start. First of all, we have to understand why is this act introduced? What is the meaning of prevention of money laundering? As the name says, prevention, to prevent the money laundering, right? Which money laundering they are talking about? Are they talking about some legal activity or illegal? Definitely they are talking about the illegal, right? To control the black market, black money circulation in the market, first of all. Okay, this act was introduced. So here I'm going to give a introduction which I have written, okay, and from this we are going to identify what are the transaction, how this money laundering act is activities are done. Okay, so let's go for it. The Prevention of Money Laundering Act was enacted by the Indian Parliament in 2002. So can I say this was enacted by whom? The Indian Parliament in 2002. Okay, let me write it, by the Indian Parliament. Okay, hope so this was clear, nothing was there else. Okay, the main purpose was to prevent the money laundering in the India. It is important legislation, especially from the economy and polity points of view. The PMLA, which is Prevention of Money Laundering Act 2002, it came into the force in 2005. Okay, the chief objective of the legislation is to fight money laundering, that is process of converting black money into white. Okay, money laundering is the process of concealing the origin of money obtained from isolate activities, which I can simply say the illegal activities. Okay, so the money which is obtained from illegal activity, okay, that is engaged in some any other activities, okay, in circulating in any other activities, and from that the money, black money, is converted into white. Okay, so like the drug trafficking, bribery or fraud. The purpose is to introduce illicit fund into the financial system under guise of clean money. The main agenda is to convert that black money into the clean money. Okay, so that the criminal can use it without the attracting undesirable attention from the authorities. Money laundering can often happen even when company employees are unaware. It's now a myth that only financial companies are vulnerable to money laundering, as criminals exploit various industries from sports to arts to launder illicit funds. Another unexpected example of money laundering is through charity. Okay, so we are thinking that charity is done like for betterment of people. No, okay, most of the time definitely to get the tax benefit. We know the deduction donation under section 8 and all. Okay, so we know while we are contributing any donation to charitable activity, charitable contribution, okay, we get a deduction under section 8, this we know well. Okay, but what happens, for example, there is some institution, okay, and a person is approaching the institution, okay, and that person wants to get the deduction or wants that money. Let's take black money, okay, he is investing that black money in charitable institution, okay, and definitely somewhat happens ki the institution keeps some money, okay, there is some agreement between that X and the charitable institution, okay, and that money is reconverted, okay, which means recollected by that Mr. X who have given the charitable institution charity. Okay, so here in front of tax authority, he is a clean person, he have paid the tax, okay, he had claimed the deduction under section 8 and unknowingly he have recollected the amount, okay, because the transaction, only deduction under section 8 and all are only taken once the transaction done in bank, through the bank, right, by any other forms also, but not in cash. Okay, and the recollection of money by Mr. X, from that charitable institution is done in cash. Okay, so there are so many activities involved here. So let's go for the other thing. The main objective of this act is to prevent definitely money laundering, combating the channelization of money into illegal activity and economic crimes, providing for the confiscation of property derived from or involving money laundering, providing for any other matters connected with or incidental to the act of money laundering. Okay, so these are the other major objective of PMLA. Okay, let's go for what are the offences under PLMA. Offences mentioned under Part A and Part C. So can I write here there are offences? Okay, there are Part A, which is related to Part A, okay, and Part C. Okay, of the schedule of this act will attract its provision. Part A include offence under acts, namely Indian Penal Code, Prevention of Corruption Act, Narcotic Drugs, Psychotropic Substance Act, Antiquities and Art Treasure Act, Trademark Act, Wildlife Protection Act, Copyright Act and Information Technology Act. Okay, so let's go for what is written next line. I'll define it. Okay, Part B include offences that are mentioned in Part A but are of value ₹1 crore or more. Okay, and Part C includes trans-border crimes. So can I say there are three parts: Part A, Part B and Part C. Okay, normally if a person is involved in PMLA, okay, prevention money laundering and all, okay, so he is covered in Part A. Let's say this. Okay, so what about the Part B and Part C? Part B is saying that the activity which is included in Part A, okay, ये Part B है, activities which are included in Part A and plus the amount is more than 1 crore. Okay, which, let me say it again, the Part B includes offences that mention in Part A, ठीक है, हाँ जी, and in Part A but are of value of ₹1 crore or more. So is this clear? Part A simple, Part B is definitely those activities included in Part A and that values is more than 1 crore. Okay, ठीक है. What about the Part C? Part C says about the trans-border crimes. ठीक है, trans-border crimes. Okay, so hope so there are three parts which is mentioned. So you guys have to tell me, okay, you guys have to tell me this part cover in which part. This I'll say it again, let me rub it. Okay, okay, so the Indian Penal Code, Prevention of Corruption Act, Narcotic Drugs and Psychotropic Substance Act, Antiques and Art Treasure Act, Trademark Act, Wildlife Protection Act, Copyright Act and Information Technology Act. So you guys have to tell me these things are covered in which part. Comment below, guys. Okay, let's go for the other part. Method of operation. Now we are going to discuss 3 steps of money laundering. Okay, there are 3 steps involved in money laundering. First is placement. Okay, second is layering and third is going to be integration. So before going, let's start it. I have to tell you a simple example. Let's go with one example first. Okay, so for example, Mr. X, he is involved in criminal activity. He is a criminal, he is a gunda, ठीक है, and he is getting money from doing criminal activity, ठीक है, which means he is getting money from gundagiri. As like Gandhigiri, there is gundagiri also. So he is getting the money from gundagiri, right? For example, the criminal activities he is doing, he is getting from 1 crore to 20 crore. Let's do an estimation. Okay, he is getting 1 crore to 20 crore in between. Now this Mr. X, this criminal, wants to open a restaurant. Okay, and what he done? He opened a restaurant. For that he have gone to the bank, okay, and he have taken loan. Okay, so what happens? He have taken the loan from the bank, financial institution and all, okay, and he have opened the restaurant what he wants, okay, and he's monthly or yearly basis, he's paying the repayment interest amount and principal on repayment of interest. Okay, so what is happened here? He is having that criminal money, the money which he gained from the criminal activities, but he have not spent that money. Okay, if he want, he can definitely go with that amount, but what he have chosen, he have approached his bank, okay, and he have taken loan from bank, right, and he is repaying the amount from that criminal activities money. Okay, so he is paying tax to the government, right? He is showing that the revenue earned from that restaurant, he is earning that revenue from the restaurant. Collection is from restaurant. Income of source is what? The restaurant income. Okay, so he is paying tax to the government, right? Now he is being a very citizen of our country. Okay, so what he is doing? He is paying tax to the government, as well as he is paying the repayment of interest monthly or yearly, whatever we can say. Okay, so what he have done here, he has converted that black money to the white, means the clear money, right? This is what happens in this. So there are different 3 stages. First is placement, second is layering, and third is integration. So let's go for it now. Okay, method of operation. The first stage is when the money derived through the crime is introduced into the formal financial system for the placement. Okay, keep the example in your mind. Okay, so the second stage is the money was introduced into the system. First stage, placement, where he get the money from that criminal activity, right? 1 crore to 20 crore, right? Yes. Second, he's introduced that money into the system, which means he approaches bank, right, for the loan. Okay, इतनी बात समझ में? Yes. And is layered and spread over the various transactions with clear and taint origin of the money, and is called layering. Okay, hope so this 2 part is clear. Third, in the third and final stage, the money enter the financial system in such a way that the original association with the crime is sought to be cleared, so that the money can be used by the offender or a person receiving it and clean money through the integration. Remember the example what I said? He have approached loan, he have get that money from criminal activity, first step, okay, which is of what? Placement. Second, layering, where he have approached the institution, financial institution, he have taken the loan. Third, he is paying back, right? He is getting revenue, he is showing the revenue from the restaurant, and he is paying the amount to the government, right, and is repaying the amount of interest to the financial institution and all. Okay, so this was the third step involved, which is called integration. Hope so up to this is clear. Let's go for the step one by one now. Okay, this was a little bit description about the 3 steps. Let's go in depth now. What is the placement thing? Money laundering stage 1 is of placement. Placement is illegal fund into the financial system, may happen directly or indirectly. The most popular method used in placement stage is to divide large amount of cash into less suspicious smaller sum, which can then be deposited into a single bank account or several bank account. Okay, so what is happening? We are simplifying the complex procedure here, right? So we are diversifying. Okay, what happens in portfolio? Okay, what happens in portfolio? We used to diversify, right? We don't invest in one securities, right? We are investing in different platforms. Okay, in this what happens will get written definitely, and risk possibility is going to be less. Okay, this is the same thing going to happen where the large amount of cash, is suspicious is actually broken to the smaller sum. Okay, so let's go for the other thing. Smurfing often occurs when the money service business. Okay, this is the technique which is involved in this step. Let's go for the second thing which is written. Other placement method include false invoicing. Okay, we know this, over invoicing, and the under invoicing. This is under for the payment of non-existing good or the services. Okay, and blending illegal money with the legitimacy money, buying foreign currency buying securities or insurance with the cash, and gambling and betting on the sports game. They are the other method involved in the very first stage of placement. Let's go for the layering, guys. Layering is a process of separating illicit means the illegal money from the source and creating the layer of the transaction to confuse and audit. The purpose is to hide the origin of illegal obtained asset. This stage is considered to be the most complex as it involves multiple transactions, often including international money transfers. For the purpose of layering, money can be moved through the purchase and sale of investment or through a series of accounts at the bank in different countries. Okay, most often such funds are directed to jurisdictional which have loose AML regulation or do not cooperate with the AML investigations. So the most popular example under layering is investing in real estate. Okay, reselling the high value assets. Okay, transferring funds into the country, and chain hopping, which is converting one cryptocurrency to the another and moving crypto from one blockchain to the another, and number of others. Difference between placement and layering. Okay, while placement inject the illicit fund into the financial system, layering hides the source of these funds through the series of transaction financial tricks. So can I simply say what happens in layering, placement and layering involve a lot of transactions. Okay, so the person cannot identify the illegal money is actually involved in any of the other activities. Okay, and first step was of the placement, where this illegal activity money is introduced. Okay, so this is the difference between these two. Let's go for the integration now. After placement and layering, criminals then integrate, or other word, return the illicit money to themselves in a way that appear, which is clean. If this stage is successful, the funds are now part of legitimation financial system and can be used freely. Okay, the main objective here is to integrate the money without drawing the attention of law enforcement. This can be done for the instance by purchasing properties, purchasing art, right, purchasing jewelry or luxury automobiles. Okay, I'll tell you one example, a real life example. What happens, one of my friend, I'm having different friends from different field. Okay, so one of my friend is artist. Okay, I'm talking about the demonetization phase. Okay, in 2018, right? So he's an artist, and all of sudden during that demonetization phase, all of sudden he got a call that hello, I want to purchase some of your artworks. And when my friend discussed this with me, I was very shocked. In this time when people are not having money, we cannot take money from ATM, we cannot have more transaction, right? At that time this happens with us, because I was staying in PG and I wasn't having that much money with me. Okay, so we have to be in queue to take the money from the ATM, and we cannot do more than one transaction. For one person you can only do the one transaction. And my friend asked me, yaar, ki this happens, somebody calls me, and that is through authorized dealer. Okay, so I asked, definitely you should go for it. Okay, and what happens when I get to know the actual reason was to hide the black money, right? What happens, what he have done at that time, the main motive of Mr. Narendra Modi sir was, our Prime Minister Shri Narendra Modi sir, was to what? To control the black money, right? Because black money was circulated in different ways and we couldn't identify it. Okay, he was thinking by blocking the sources we can definitely identify the black money sources, or we can definitely control the black money which is circulated in the market. Okay, so through this one was the example, the live example which I have seen. Some of the artwork was sold out at that time. even when we were not having money with us. Okay, so these are the things which simply people can do. Okay, buying, the purchasing an asset, jewelry, and the artwork and all. Okay, so let's go for the other part, the impact of money laundering. Here are only a few of negative consequences that ML brings to the business. ML, money laundering: loss of revenue, reputation harm, multi-million-dollar fines or license suspension by the regulators. Moreover, money laundering has damaging socio-economic effect worldwide, including fueling corruption, increasing crime, undermining trust of foreign investor, widening the gap between rich and poor, and slowing economic growth. Now, let's go how the money laundering works. Dirty money is acquired through illegal means. Okay, criminal launders the money where the source are distinguished and deposit in the bank. Then clean investment and purchase of luxury asset and clean money enters the economy. This is actually how the money laundering actually works. Okay, so let's go for the punishment for the money laundering. The act prescribed that one person found guilty of money laundering shall be punishable with rigorous imprisonment for 3 years to 7 years. So can I say the imprisonment is from 3 years to maximum 7 years. Okay, this is going to be the imprisonment, rigorous imprisonment. Okay, so the imprisonment would be from 3 years to 7 years, but there would be some other cases also involved here. And where the proceed of crime involved related to any offence of para 2 of part A of the schedule. So can I simply say this is for part A, para 2. Okay, now let's go for the other part. If offences under the Narcotic Drugs Psychotropic Substance Act 1985, if any of the person is involved in such activity which is of Narcotic Drugs and Psychotropic Substance Act 1985, then in that case the maximum punishment would be extended to 10 years. Okay, in case of narcotic, can I write it? Narcotic Drugs and Psychotropic Substance Act. Okay, definitely it's from 3 year, maximum limit is going to be 10 year. Hope so this point was also clear. Let's go for the other penalty under PMLA. Various actions can be initiated against person found to be guilty of money laundering. Such act: freezing or seizing of property and records, or attachment of the property obtained through the crime proceeding. Okay, money laundering is punishable with, we know this, the rigorous imprisonment of minimum 3 years, maximum 7 years. In case of narcotic and the psychotropic substance, is going to be 10 year maximum. Okay, minimum it's going to be 3 years. Hope so this was also clear. Fine, if the crime of money laundering is involved, definitely we have covered this, it's going to be up to maximum 10 years. Okay, what are the common forms of money laundering now? The below are the some of the common methods of money laundering: hawala, bulk cash smuggling, frictional loan, cash intensive business, round tripping, trade based laundering, shell companies and trusts, real estate, gambling, and fake invoices. Okay, some I have already covered earlier. So let's go with the other part. What is this adjudicating authority saying? Under the PMLA, who is going to appoint this authority? The central government has the power to appoint the adjudicating authority. To exercise power and authority confers under this act, an adjudicating authority must be consist of a chairperson, okay, two other members, out of which one individual must have experience in law, administration, finance, and accountancy field. So can I write here first person, chairperson? Okay, apart from them, apart from chairperson, two other member, okay, who must have at least among them one should have the experience related to law, administration, the finance, and accountancy field. So can I say chairperson should be there in the adjudicating authority. Second two person, any from among these two, one should have the experience, knowledge related to law, administration, finance and accountancy field. An individual in the field of law can be a member of adjudicating authority if she has qualification to be appointed as judge of any district, or has been representative member of the Indian legal service, or has held a post grade first of the service. Okay, the bench of adjudicating authority will operate in New Delhi and also location specified by the CG. Okay, so the central government have power to appoint the adjudicating authority, and there are some specified members should definitely have some specific knowledge related to this field. Okay, field of law, accountancy and all. Okay, and one chairperson should be definitely appointed. So what is the power of adjudicating authority? Why the central government is going to appoint this authority? Okay, so let's go for it. The adjudicating authority will issue a notice to a person against whom it has received a complaint of money laundering offensing under the PMLA. Okay, so the AA, the adjudicating authority, can I say AA? Yes. Okay, the A is going to issue the notice. Notice is issued to whom? Okay, notice is issued to a person against whom? Against whom the AA have received a complaint of the money laundering. Okay, so those person, if any of the evidence is having, right, or any complaint against that person which is related to money laundering here only. Okay, so AA is going to issue the notice against that person. Okay, hope so this point was clear. It can issue notice such a person calling him to indicate the source of his income. Okay, so A is going to say you have to indicate in that notice, you have to specify the specification is going to be about the total income, the sources of income. Okay, earning, asset out of which he or she has acquired the property attached, seized, frozen by the director appointed under this act, and to show why such property should not be declared as property involved in money laundering and confiscated by the central government. Okay, so definitely if the AA is having any of the evidence against that person who is actually involved in any of the activities of money laundering, okay, in that case the A is going to issue the notice against that person, and he is going to specify that from what are your sources of income, how many income earning is your. Okay, the person have to specify each and everything, and he'll simply ask, the A will simply ask, can you show me some evidence, okay, that this property of yours is not by the money laundering earnings. Okay, so you have to give the proof to the A, the person, the accused person here. Okay, have to give the proof to A. Okay, hope so this point was clear. The A will record a finding whether all of or any of the property referred in the complaint are involved in money laundering after considering a reply from a person accused of the offence, hearing the aggrieved person and the director, and taking all the evidence into the account. When A decided that the property is involved in money laundering, the person is accused of offence will confirm in writing the attachment and seizing or frozen of the properties. So these are the power which is with A, right? He can freeze the asset of that accused person. Okay, so he can go for freezing. Okay, he can freeze, right? He can seize the property of the SSE, accused person, right? But before doing that, he have to give a writing, in a writing. Okay, otherwise he cannot go for it. Okay, let's go for the obligation of the bank and financial institution and intermediate to maintain a record. Do the bank and financial corporation institution have to maintain some record, and if yes, so what is going to be the time limit, for how many years they have to record, they have to file they have to save that record. Okay, and is there any limit, which I mean, is there any limit, if the limit crosses this particular criteria, then only they have to keep that record with them, right? Or the financial institution, there is no limit with them. Okay, let's go for it. The financial institution, bank and intermediates have the following obligation under the PMLA. They have to maintain a record of every transaction and amount, irrespective of whether such transaction is carried on in one go or where series of transactions having internal connection with each other when such series occurred within 30 days. So what I told you, they have to carry maintain each and every transaction. Okay, to inform the director appointed under PMLA such transaction within allotted time. Okay, to verify the identity of the clients, to keep records of all the documents related to identify the clients and beneficial owner, account file and business transaction relating to the client. So these are the things which the financial institution, bank have to do. These are the obligation. Can I simply read it again? Yes. They have to maintain a record of each and every transaction, okay, irrespective of whether the transaction were carried on and all, take a series of transaction or not, okay. But from when such a series occurred within 30 days, from that actually occurred, okay, from the 30 days, okay, they have to keep that record of the accused person. Okay, don't get confusion, let me tell. Once the A have given the details, the notice to the accused person, right, and once the final order is made by A, right, from that 30 days, it's the obligation of financial institution bank to maintain this record, okay, from the series occurred within 30 days, okay. Hope so now it's clear. They have to maintain the records of each and every transaction amount. They have to inform the director appointed at PMLA of such transaction within allotted time. Right now they have to, it's the duty of financial institution and bank, they have to inform the director who is appointed under PMLA, okay, verify the identity of the clients and keep a record of all the documents related to identity of the clients, beneficial owner and all, okay. So these record must be kept for how many years? MCQ question, chalo theek hai, dekho 5 years from the time the transaction took place. Director appointed under PMLA has power to look into the record into bank, financial institution, intermediaries. If the director find out that the bank, financial institution or intermediaries have not kept the record, he she can levy a fine ranging from 10,000 to 1 lakh. Okay, what happens if the director find out that this bank, this financial institution, these intermediaries have not kept the recording with them, okay, or not after 5 years, okay, we are not talking about the 5 years, they have not kept the recorded, okay, or they have kept the recording only for 2 years, even though 2 years, sorry, and they have to keep it for 5 years, right. So what is going to happen? The director can levy a fine from 10,000 to 1 lakh. However, no civil or criminal case can be filed against the bank, financial institution or the intermediaries. Okay, so this was this point saying, is there any limit here? No, there was not any other limit here, right. So what happens? The director, once this transaction happens within the 30 days, okay, the bank, financial institution and intermediaries have to record all the transaction, all the amount, the identity of the accused person, okay, the bank transaction, the sources and all, each and everything they have to record it, and they have to inform the director who is actually appointed under PMLA. Hope so this point was clear, okay. What happens? The bank, financial institution, intermediaries have not recorded the record of the accused person, that case, for how many years? For 5 years. For 5 years. Okay? If they have not recorded, then fine. Imposition by whom? By the director of minimum 10,000, maximum 1 lakh. Okay, hope so this point was cleared. Okay, but there is one more thing, no civil case or the criminal case can be filed against bank if they have not kept the record. Okay, so there is only penalty imposition, not anything else. So can the person go for the appeal, and within how much days? Is there any time extension again? So we are going for it, appeal to the appellate tribunal. Save as other provided in section 3, subsection 3, the director, any person aggrieved by the order of AA under the act may prefer to an appeal to the appellate tribunal. We are talking about the director or the any other person, the aggrieved person, right? They can go for, the order was from Adjudicating Authority, right? Yes, aggrieved from the order of Adjudicating Authority. In that case, they can prefer, they can file an appeal to whom? The appellate tribunal. Okay, hope so this point was clear. Any reporting entity aggrieved by the order of director made under subsection 2 of 13 may prefer the appeal to the appellate tribunal. So what, in very first point what I said, the any director or any aggrieved person can go to the for the appeal to appellate tribunal. Okay, by which, by the order of agreed or order of whom, the adjudicating authority. Second point says any aggrieved person by the order of whom, by the director, okay, they can file an appeal to definitely appellate tribunal. Okay, so in this case order was finalized by director. Okay, any aggrieved person can go for the appeal. Okay, so can I say agreed person? Okay, let's go for every appeal preferred under subsection 1, subsection 2 shall be filed within how much days? This is important. Okay, for MCQ. 45 days from the date on which copy of order made by adjudicating authority or director is received and shall be in such a form accomplished by fees as may be prescribed. So, within how much days? Within 45 days. Within 45 days from the order made by A or director is received. Okay, hope so this point was clear. Provided that appellate tribunal will have to give an opportunity of being heard. Okay, after giving opportunity of being heard, entertain an appeal after expiry of such 45 days. If it is satisfied that there was sufficient cause for not filing it within the prescribed time. Okay, on receipt of appeal subsection 1 or subsection 2, appellate tribunal may giving the parties to appeal an opportunity of being heard pass the order of rethink, confirming, modifying, setting aside the order appeal against. The appellate tribunal shall send a copy of every order made by the parties of appeal to the concerned adjudicating authority and director. In this case, the appeal filed before the appellate tribunal under subsection 1 and subsection 2 shall be deal with the expeditiously as possible, and endeavour shall be made to and dispose appeal finally within 6 months from the date of filing of appeal. So, let me say these things in very short. Okay, who is going to file an appeal to the appellate tribunal? Number first, director, okay, or the aggrieved person, right? First point says about the director and aggrieved person. Who is from the order of whom? The AA, adjudicating authority. They are not satisfied by the order of AA. They can definitely go for the appeal to appellate tribunal. Second point says about the any accused person of which order? The director's order. The person is not satisfied by the order of director. In that case, they can go for the appeal to appellate tribunal. Okay, but within how much days? Within 45 days. Okay, so within 45 days, they have to file an appeal to whom? To the appellate adjudicating authority, appellate tribunal. Okay, okay, hope so this point was clear. Let's go for, is there any opportunity of being heard given? Yes. Before finalizing the order by the appellate tribunal is going to give the opportunity to either to the director, definitely in case if the order the appeal was given by whom? By the director, or a person, accused person. Okay, so hope so this point was clear. And within how much time limit the disposal of appeal is to be made? Within 6 months. 6 months from the date of filing of the appeal. Okay, the application is to be disposed. Okay, what if by the order of appellate tribunal the person, accused person or the director is not satisfied? Can they further go for appeal? Yes, they can further go for appeal to the High Court. Within how much days? 60 days. Above it was 45, in this case going to be 60. Let's go for it. Any person aggrieved by the decision of order of appellate tribunal may file an appeal to the High Court within 60 days from the date of communication of order or order of appellate tribunal to him on question of law or fact arising out of such order. Okay, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it will be filed within further proceeding not exceeding 60 days. In both cases, right, extension was granted. Okay, for the above 45 days was extension, and in this case it's 60 days. Okay, so hope so this point was clear. This is going to be end of this chapter, guys. I've covered majorly, I can say, the major parts, right? So now we know what is the meaning of money laundering, why this act is made, prevention of money laundering, okay, 2002, okay, why this act was introduced, and what are the stages. There are 3 stages, right? Comment below, okay, and which stages define which part, what activity is going to be involved in each of the part, each of the steps, and the record maintained by financial institution, appeal against the order of adjudicating authority, and who is going to constitute the adjudicating authority, the central government. Okay, these are the small things which we have to keep in mind. This may come in form of MCQ. Okay, and what was the bank financial institution, they have to keep the record for 5 years. Okay, and is there any other action taken against the financial institution and bank if they are not maintaining the record? No, 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 no. Only fine imposition is going to happen from 10,000 to 1 lakh. Okay, and appeal from the order, if the person is not satisfied, okay, in that case, order of adjudicating authority, they can go to appeal to the appellate tribunal. Otherwise, once they are not even satisfied by the order of appellate tribunal, they can go for the high court. Okay, 45 days, 60 days, extension 45 days again, and extension 60 days, not more than that. Okay, so hope so up to this was clear to you. If it was, then what you have to do, hit a like button, subscribe my channel, and share this video to the CA CMA aspirant. That's it. Keep your revision, stay consistent, and stay healthy, stay hydrated, guys. Drink water as much you can. Okay, that's it. This is Soumya Santosh. We'll meet in our next video. Tab tak ke liye, toodles.